Hello, hello, hello. How is everyone? Can everyone see me? Give them just a few more minutes to let everyone into the room. Running a little bit behind, had a hard time getting set up, but we are set up and we are live. So make sure that you come on in the room, and when you get here, share this. And if you're catching this on the replay, still share it. Hey, attorney's best friend, how are you, Mr. Quetta? So like I said, when you come in the room, it's gonna take a few minutes to let people come in. So I'm running a little bit behind. I had a hard time setting up Periscope. So we are in. Make sure that you share this out with anyone that you think can use the information. Today we're going to talk about how to use trademarks and copyrights to protect your designs. I was in a Facebook group discussion over the weekend, and this was a big thing. Apparently last year, or in 2015, Real Housewives of Atlanta, Nene Leakes stole a t-shirt design by teasing the trap owner, Asha Jones. It was the girl by t-shirt design. So we're going to talk a little bit about that, because I get a lot of calls and emails about protecting short phrases and things of that nature. So in just a few minutes, we're going to get started. And I'm primping in the camera as always. Hey, thank you so much for coming in. Make sure you share this out with your friends. We have just a few minutes to get started, and we're going to get started in a few minutes because this is going to be about 15 minutes. It won't take up much of your time, but I really wanted to talk about this. Hey, thank you for joining. My name is Attorney LaConya Murray. I am the small business attorney, and I help clients throughout the United States with trademarks, copyrights, and business development solutions. Today, we're going to talk about trademarks and copyrights as it relates to protecting designs. So, what I will invite you to do is actually share this out. If you could share this video out and invite anybody that you know that's an entrepreneur, thinking about being an entrepreneur, or a designer that creates logos or anything of that nature, just tell them to come on in, get some knowledge, get some of this free legal education. All right, here we go. Wait a minute, hold that thought. I left my outline. And I'm back. I have an outline. Okay, so today, talking about trademarks versus copyrights when it comes to design. And what you really need to know, first of all, there is a difference between trademarks and copyrights. I get a lot of calls saying that I need a trademark when they really need a copyright, or they need a patent when they really need a trademark. And people get them confused and use them interchangeably, but they cannot be used interchangeably. They offer two different types of protection. The trademark is for, trademarks protect brand identifiers. I tell you right now, I could have been a doctor with my handwriting. But what we mean by brand identifiers are really those things that protect the source of a good or a service. So if it's something that identifies the source of a good or a service, it's going to be protected, or can be protected, by trademarks. So let's say brand identifier is the source of a good or service. So that's what trademarks protect. So even if you have a design, that you're using as a logo, as a brand identifier, then it can absolutely, well, I won't say absolutely, if it qualifies, it can be protected as a trademark. But that same logo that you're using to identify the source of a good or a service can also be a copyright if it's an original work that's in a fixed, tangible form. And so what do we mean by original? This right here, this original is what gets people, oh, can you guys see the board okay? Can you see the board okay? Good. So what do we mean by original? Original means that it is independently created and it contains at least a minimum source of creativity. So when people are accused of copyright infringement, a lot of times their first defense is that, well, the work is not creative, it doesn't contain any creativity. But the threshold for creativity is low. But it has to be independently creative. So I always give the example, because some people say, well, it's a copy of mine, it looks just like mine. That's not the test. The test is whether or not it was independently created, meaning that if I'm sitting here in my office in Alabama and someone is in Texas in their office, we don't have access to the internet, we both write books or poems. Let's make it short. Let's say we both write a poem based off our experiences with the whole election, and those poems turn out to be very similar. We both own the copyright to that. She didn't copy mine, and I didn't copy hers. Even though they seemed the same, they were independently created. And that's the test. It's not who did it first. If we both did them at the same time and they were independently creative, I didn't have access to hers, she didn't have access to mine, we both own the copyright to it. Does that make sense? So that's what we mean by independently creative. And I have an outline. With trademarks, and the reason, so oftentimes I advise my clients to get both a trademark and a copyright is because the protection overlaps. So first of all, your trademark is going to protect anything, any business. It's going to prevent any business that's in the same or related field from using a logo or a design that's similar to yours. So over here, you have similar, while over here, you have same. So you have the protection is expanded if you're using it as a brand identifier. And as long as you're using it as a brand identifier, then you will have the authority to use that as a trademark. It does not expire. As long as you're using it, it's yours. Now, what happens is, I just saw this in a Facebook group I was in. They were talking about the evolution of trademarks and evolution of logos and how they change over time, this, that, and the other. They do change. And they gave the example of Walmart, and they showed Walmart's logo, how it first started out with just Walmart and bold letters, and then I think one time it was brown, then one time it was, it had the wall with the hyphen in the middle and the mart, and right now I think it's Walmart in blue letters with a yellow star. Each one of those are logos. Each one of those are brand identifiers, so they are protected by trademark laws. But each time they change and make a change to their logo, they have to register that new logo. So that's something to keep in mind. And that same logo is protected by, well, actually, it might not be protected by copyright law, because that same logo, it is a word mark. Their logo is a word mark. It is text, and copyrights do not protect short phrases. So let's jump into that really quick about designs. Because when most people are talking about designs, they're talking about them coming up with a short phrase and profiting off of that and preventing other people from doing the same. You cannot copyright a short phrase. That's just the way it is. So, and the reason that's important to know is because if you have a short phrase that you put on a t-shirt or a mug or a journal or something of that nature, and it's used for decoration purposes and not to identify the source of a good or a service, it's not a trademark. It's going to fall under copyrights. And you have to be able to play by copyright's rules. So copyrights say that we don't protect short phrases. That's the rule. But if you have some type of design something to go along with that short phrase, then that can be protected. So in the case of Nene Leakes versus Arsha Jones, the reason she was successful is because Nene Leakes copied the exact design. And part of the design was using a stylish font that was created, I'm going to assume, by Arsha Jones, because fonts can be protected. The software used to create fonts is what's protected, and you have to have a license to use different fonts. And so Nene Leakes used the exact same font without permission, which is why she was able to, Ms. Jones was able to successfully win that battle, because if you go on her Nene Leakes page, you see she still has a Girl Bye shirt. It's just not the exact same design as Miss Arsha Jones. So do we have any questions? I know that I'm going fast because this is 15 minutes, but do we have any questions? I'm looking on my Facebook Live and I can't tell what's going on here. I don't know, I can't tell. So some of the things, let me see. I love my dry erase board. Good info? Thank you. Good, good, good. I'm glad you're finding it useful. Hello, how are you, Lexus? So, as we talk about copyrights, in design, but you need to know that some things they do. When we talk about minimum creativity, there's some things that the Copyright Office, they just don't take into consideration. It just doesn't matter. It doesn't matter how long it took you to come up with it. It doesn't matter what the value is, and it doesn't matter. Hold on a second. I have notes. How much people like it. You know, those things are not taken into consideration when you're talking about copyrights. Because again, they're just some things that can't be protected. So if you have basic, I can't spell, hold on. So basic geographic shapes are not protected. Familiar symbols, not protected. Short phrases, which we just talked about, not protected. And there's some other things. So the question is, let's talk about if you have something that you created and it doesn't fall under these exceptions. So it's something that's original, it meets the threshold of minimum creativity, and it's original, I think I just said that, and it's fixed in a tangible form. Because remember, copyrights do not protect ideas. You can have it up here all day long. You can tell people, oh, I'm going to do this and I'm going to do that. Songs and music, that's going to probably be a scope for another day. This one is for designs, and this scope is kind of short, but I'll make that one. Send me a question to my Facebook page, and we'll make it for the next Thursday. But so, like I said, you can tell people about it. Oh, I'm going to do this, I'm going to do this, I'm going to write a book, I'm going to draw a picture, I'm going to have this great logo. But until you actually do it, then it can't be protected. And speaking of that, if you do have this great idea, but you don't have the skills to execute it, like I'm not a graphic designer, I can't draw a thing. So if I need any work done, I always hire someone. That person, even though it's your idea, even though you told them what to do, that person that created it is the author of that work, and they own the copyright to it. Do y'all hear what I'm saying? They own the copyright to it. That means that they have a say-so in how you use that work, and you have to get their permission in order to use it commercially or even personally. If they say, hey, you can't use this work outside of just on business cards or letterheads, then you cannot use the work they created. You cannot take that logo or that design and put it on a t-shirt or anything else without their permission, because they own it. So that's why it's good to have these conversations up front about copyright protection and assignments, who's going to own what, and then get it in writing. So if you need a copyright assignment, which is the agreement that you need to go to our website and check out our document bank. Yeah, go to courses.offthemarkipsolution.com, check out our document bank, and we have a copyright assignment in that document bank. So you have this work, this original work that's in a fixed tangible form. Now what? What can you do? You need to register it. You need to register it with the U.S. Copyright Office. Now, I will tell you, you do have a common law interest. You have a common law interest in your work. However, your recourse is going to be limited without the copyright registration. You're not going to be able to get damages and things of that nature. You'll be able to stop them from using it, but you won't be able to sue them in federal court without a registration. And you want to register it, if you can, register before you put it out in public, because you want to do it before you have someone has the opportunity to infringe on your work. You have 3 months, like 3 months from the time that you actually start using it before you can still qualify for that statutory damages. Yeah, so, and statutory damages are pretty cool. So let's go back to the example of the t-shirts, right? Let's say the t-shirts sell for $25 a piece. Let's say, so instead of an infringement, the way infringement works is, let's say that same t-shirt, let's say Nene Leakes sold one t-shirt. That's one instance of copyright infringement. Let's say she sold 100 t-shirts. Class, can anyone tell me? That means that that was 100 instances of copyright infringement. And so it can stack up and the fees can get pretty hefty. And the good thing about copyrights are that it's not expensive to register your work. It can range up from $35 to $55 to register your work. So it's something that can absolutely be done. If you want someone to do it for you, my office, that's the service that my office provides. We absolutely do copyright registration. Our fee is $275, which includes the registration fee. If you want to learn how to do it yourself, check this out. I have a copyright masterclass that's on our website, and it's only $99. And we walk through everything. How to, we talk about what can be protected, what can't be protected, how to complete your application, and it even includes some cease and desist letters and other templates in order to actually enforce and protect your work. So how does this sound to everybody? This helping people out? Let me know if you have questions. Hey, how you doing? Thank you for coming in. How long is it protected? Excellent question. So you have copyright protection 70 years after the death of the author. Or if it's owned by a corporation, it's 120 years. So the life of the author plus 70 years, if it's an individual that owns it, or 125 years, 120 years if it is, that's actually 125, where's my eraser? I don't know. 125 years if it is a corporation. Excellent question. Any other questions? And I'll get out of the way of the board. You are very welcome, very, very welcome. Let's see. Find my eraser. So if you want more information, Make sure any questions. Let's see. Don't see any questions. Okay. If you have questions, about our services and what we provide, you can absolutely schedule a complimentary discovery call to talk with us by going to bit.ly/10-minute consult. And the min is abbreviated, so bit.ly/10-minute consult. And if you want to learn more about copyrights, definitely I would recommend taking the copyright masterclass. Even if you don't have any intentions of completing and going through the process yourself, I believe as business owners, entrepreneurs, you have a duty to know this information. You have a duty to know what can and what can't be protected. You have a duty and obligation to know if you are infringing on anyone else's work, because the course also talks about, because every day people are infringing on other people's copyright and intellectual property, and they have no idea they're doing it because everyone else is doing it. By now we know that you can't, just because you see a picture on Google, you can't right click it and put it on your website. You have to go and make sure you find pictures that either have a license and you purchase a license for it, and you need to read what type of license you have. That's another thing. When you get these things, when you make these purchases, when you're using different fonts for your designs, you need to read what type of license you have. A lot of these licenses are for personal use only, and they're not for commercial use. And so if you're using a font that's for personal use only, for commercial purposes, you're infringing on someone else's copyright. If you are using a font that says for commercial use and you're using it and someone copies your design, you don't own, you just have a license to use it. You don't have the authority to tell someone that they can't use that font because that font doesn't belong to you. They just let you borrow it or use it. It's something else to take into consideration. But absolutely go to courses.offthemarkipsolutions.com and sign up for the $99 copyright masterclass. We talk about all of this. Then if you have any questions, you can always drop them in the discussion box and we answer those questions there. So if there are no more questions, any questions? No more questions? All right, that's awesome. I'm going to talk to you guys later.